Hello, everybody. It's Walter, your favorite historian, professor, educator, and social studies extraordinaire, here today to discuss with you how Congress absolutely has the power to impose a code of ethics for the Supreme Court of the United States. So, our context first. Due to the recent revelations of serious financial improprieties and otherwise engaged in by U.S. Supreme Court Justices Clarence Thomas and Samuel Alito, and subsequent congressional investigations into those improprieties, it has led the Democratic members of the United States Senate to impose a code of ethics on the Supreme Court of the United States, because the Supreme Court itself has failed to ensure proper disclosure of certain activities that would otherwise be seen as unethical, compromising their impartiality. Okay? And that, my friends, has started a debate among many in the legal community over whether or not Congress has such a power to impose a code of ethics on the Supreme Court of the United States. Well, I, for one, as an authority on this subject, make the firm argument that they absolutely have such power. There are many, though, who do not agree and argue the opposite, that Congress has no such authority, and that it would violate the separation of powers between the two branches of government for Congress to impose a code of ethics on the court. Those who make that argument, however, clearly are lacking knowledge in both history and the Constitution itself. So allow me to defend my position. First and foremost, the history. The framers of our Constitution gave broad, and I don't mean just mildly broad, but seriously broad power to Congress to regulate the Supreme Court and any other federal courts that might be created over time. This was not an accident, folks. In giving the federal judiciary life tenure, they knew that it would be susceptible to tyranny, and thus it would need to be kept in check and kept in line. And one of the ways to do that was to give Congress the power to keep it in line. Okay, so now we move to the Constitution. Article 3, Section 1 of the Constitution gives Congress the power to bring a Supreme Court into existence, which it did in 1789. That same section gives Congress the power to set judicial salaries, set the number of Supreme Court justices, and establish lower federal courts beneath the Supreme Court or eliminate such courts. Moving on to Article 3, Section 2, Clause 2, in a provision known as the Exceptions Clause, Congress has complete and absolute power to regulate the Supreme Court's appellate jurisdiction as it sees fit. And what that means is Congress, at its own discretion, can completely remove certain types of cases from the court's jurisdiction. Did you know that? Yes, they have that power. All right, and that power was affirmed by the Supreme Court in the 1867 case Ex parte McCardle. All right, Congress has complete and absolute power to regulate the court's appellate jurisdiction. It can't touch the original jurisdiction, as we've seen in Marbury versus Madison, the holding in that decision. All right, but when it comes to the appellate jurisdiction of the Supreme Court, Congress has absolute power to augment it as it sees fit. Now, whether Congress chooses to exercise that power is a different story. But the point is, they have it. Moving on to Article 1, Section 2, Clause 5, the House of Representatives, of course, has the power to initiate impeachment proceedings against a Supreme Court justice or any other federal judge for that matter. And Article 1, Section 3, Clause 6, the Senate has the power to convict and therefore remove an impeached Supreme Court justice or lower federal court judge. So you see all these checks on the power of the Supreme Court, and by virtue of that, the lower federal judiciary. What makes these people think that Congress would not have the power to merely impose a code of ethics when Congress has plenary authority under the Constitution to do so many other regulatory actions against the Supreme Court and the lower federal judiciary? Make it make sense. When you get the answer, you tell me. But I doubt you will, because there is no answer to that, because Congress has that power, folks. And one thing that strikes me with hypocrisy is that you've got a lot of members of the Republican conference attacking the Democrats for investigating these serious improprieties, when we know darn well that if these were liberal Supreme Court justices, the Republicans would be doing more than just investigating. They'd be calling for all-out impeachment and removal had they engaged in the actions done by Justices Thomas and Alito. All right, let's just keep it 100% real. All right, the Republicans always cry foul when the Democrats step up to the plate and give the Republicans a taste of their own medicine. All right, they always think the Democrats are going too far, when in my opinion, the Democrats aren't going far enough half the time. All right, just the hypocrisy on the Republican side is amazing. But at any rate, back to the original point of discussion, Congress absolutely has that power to police the Supreme Court in this regard, because it is clear and self-evident that the Supreme Court is either unwilling or unable to do so on its own. So that, ladies and gentlemen, is my brief lecture on the subject. I would love to hear your thoughts on it. If you have any questions or comments, leave them down below, and I will be happy to answer them. Take care, stay safe out there, and I leave you with the inspiring words of my teaching role model, Mr. George Feeney. Believe in yourself, dream, try, and do good. Professor Shelton, out.